I'm Gentner Drummond. With me is Jeff Lauer. I think a lot of the credentials are losing a campaign doesn't make me qualified to be your attorney, but those who voted for me, thank you. So Jeff is, all of his professional career, he has been a title attorney. He's general counsel to Guarantee Abstract as well as Smith Brothers Abstract. So he's got the detail and the expertise. I have litigated several disputes with homeowners associations, many title disputes. It's part of my life. This is one thing I do know. When we're talking about people's land, their homes, it's emotional. You wouldn't be here if you didn't care, right? So I think we all start from a position that it's upsetting, maybe off-putting, concerning, maybe exciting, but it's emotional. Our objective, and why Leslie and about a dozen others engaged us in the fall, was to look at this from the property owner perspective. Not from Kevin Jordan's perspective, not from the HOA's perspective, from the property owner perspective. And while we are not pretending to represent all of you, and we're not, we're going to leave with you an opinion letter that you can take home with you, that you can review. We don't have a dog in this hunt. Whether Kevin successfully develops it or doesn't doesn't make any difference to me. I will tell you, though, as attorneys with fiduciary duties, we are zealous advocates for those who engaged us, and that's why we're here. So with that as a backdrop, we do know that the intention was always that this be a golf course. And in 1983, those who dedicated the deed reserved A for those purposes, and Kevin went through the stables and green space and things like that. Unequivocally, that's what the deed of dedication says. When 14 of the 120 property owners signed an amendment to the dedication and permitted Whitehawk to be created, 14 of the 120 signed it, and Whitehawk then came into existence, and there's now another 20 residents. So you've got basically 152 property owners inside this that we know as the estates that you're in. So that when that amendment occurred, there was not language, and we've looked at this just strictly from an objective perspective. What does that mean? Now, typically, when you would make an amendment, you would typically say, we're making an amendment, and to the extent that there's any non-compliance with the covenants, this act does not waive the rights of the dedication. That didn't happen. So it was enacted in 2001, I believe, and that effectively at law, I believe, it is our opinion, that act waived the restriction. Now, reasonable minds can disagree, and we can argue all day long. But now let's talk practical. So the city of Bixby entered into a PUD that legally granted rights to the developer. So there is a legal document now part of Reserve A that says Kevin Jordan and his company can proceed to develop. So if Kevin develops, maybe you all stand down and don't do anything. Or maybe, because there's some emotion in the room, some of you who are in control of the HOA or persuasive to the HOA could file a declaratory judgment action to restrain Kevin from continuing to develop and put what I will call a cloud on the title. There's a lawsuit going on in your subdivision. Kevin lawyers up. He's got John O'Connor. I've known John for 25 years, excellent attorney. He would do a great job defending or prosecuting Kevin's position. I know Drew Reese. I think he's a superb attorney, and he would do an outstanding job of arguing the position of the HOA. Drew is a very reasonably costed attorney, but in the end, you're going to spend $15,000, $25,000, $50,000, and that'll be passed on to you. The PUD does have language that if anybody challenges it, winner prevails. So if Mr. O'Connor and Kevin defend or prosecute and win, then the HOA will be, or the property owners will bear the burden of their legal expenses. So our objective, while Leslie and others engages, is just say, hey, we see that there is a divergence of opinions in the room. Do we have legal grounds to contest and fight this, or should we be persuasive to our fellow landowners, property owners, and urge them not to waste our money? And that's why we came in. So I think if Kevin proceeded without your consent, you could certainly file a restraining order action and a declaratory judgment. That would take about 2 years. As long as none of you are wanting to sell your land in 2 years, you really don't have anything to worry about. If you want to sell your land, the buyer is going to have to look at, okay, there's a lawsuit going on. What impact does that have on me? How much am I going to have to pay to the HOA to defend this, and why? Vice versa, Kevin could say, only 25% or 30% want me to do this, but I've invested money and I'm going to do it. He could file a declaratory judgment action in the court and say, here's the deed of dedication, here's the waiver, here's the PUD. What is the public policy of Oklahoma? Is it to restrict land and not develop it, or is it to proceed with development? Why is that important? Because judges get paid by tax dollars, and cities run with tax dollars. And an empty field does not provide a tax base that a home does. So you put 200 homes paying property taxes, the money wins. So that's the gravamen behind why we're engaged and what we're looking at. What we will leave with you, what we have done, so since our engagement, principally Jeff, has worked with Kevin's team to say, if there is an amendment to the deed of dedication, what does it look like? And so Jeff's fingerprints are on that document, not in its final form, but in a near final form. And then Kevin has made several representations to you, and we say that's lovely, but we need to put that in a side agreement, which is not an amendment to the dedication, but a document that is signed by the developer that's filed in the land records. So we've negotiated those two things. And whether you call it, encouragement or bribery or whatever you want to call it, what this is Kevin Jordan going the extra mile. He does not have to be here and does not have to suffer one smart aleck remark. He can develop and say, bring it on. After you've spent your $25,000 to $50,000, he gets to develop it. You're going to be angry. He doesn't want you angry, and that's why he's here. So yes, he isn't going to incent those who are cooperative. The 16 people that were in my boardroom Friday, are likely going to be signors. And when this gets through, they're going to have the right to join the master HOA and enjoy those things. I mean, it's just rational. It may or may, Jeff, have I totally screwed up everything, or everything I've said generally true so far? Okay, good. Keeps me inside the white lines. And we had a whole bunch of slides. Sorry. Hello, I introduced myself. Okay, there we got a 2-page document in the back. We're going to give you, click. There's some questions that have been raised in past meetings. I'm giving up something. What am I giving up? You're not giving up anything. Your deeded property is your deeded property. Oh my goodness, am I losing value? No, you're increasing value.